Tully Rinckey PLLC thanks the Blacks in Government Executive Committee for allowing the firm to present this free webinar to Blacks in Government members. The firm supports the goals and objectives of Blacks in Government, and we're pleased to be of service to you. Through our partnership, Blacks in Government members are entitled to 2 free half-hour phone consults per year regarding federal employment, security clearance, or military matters. Members pursuing claims receive a 10% discount on legal fees. Call us at 1-888-529-4543 or email info@fedattorney.com to learn more about our partnership with Blacks in Government and schedule your free consultation. Tully Rinckey PLLC partner Rachel S. Young Esquire provides representation to federal employees in a wide range of employment and labor matters, including claims of age, gender, race, national origin and color discrimination, sexual harassment, wrongful discharge, and retaliation. Ms. Young has practiced frequently before federal, state, and District of Columbia courts, in addition to representing clients before the Equal Employment Opportunity Commission, the D.C. Office of Human Rights, and other state and local administrative bodies. Tully Rinckey PLLC is one of the nation's largest federal sector labor and employment and military law firms. We're a full-service firm for federal and government employees with legal issues. Our attorneys together have about 130 years of experience practicing federal employment law. They are key components of a team whose targeted, aggressive legal approach has secured positive results for clients in virtually every aspect of federal employment and labor law. Don't leave the future of your federal career to chance. Call 1-888-529-4543 or email info@fedattorney.com to schedule your free consultation with a member of our team. Now, I'll turn the floor over to Rachel S. Young, Esquire.
Thank you, Stephen, for that introduction. As Steve mentioned, my name is Rachel Young, and I will be speaking today on the topic of the Family and Medical Leave Act versus the Rehabilitation Act. And what we will be talking about today deals with the interfacing and the opportunities for coverage and for protection pursuant to these 2 laws that cover federal employees. To begin our discussion, I'd like to just cover sort of a highlighted section of what the key benefits are between the 2 acts. And during the course of today's discussion, I'll likely refer to the Family and Medical Leave Act as FMLA and the Rehabilitation Act as the Rehab Act, just for brevity. So to begin, the Family and Medical Leave Act, or FMLA, provides federal employees who qualify up to 12 weeks of leave during each 12-month period. And there are a variety of reasons that can trigger your opportunities for coverage pursuant to the FMLA. And we'll go into detail on a couple of those in a couple of minutes. But for our purposes now, it affords opportunities for employees to receive 12 weeks of leave if they need to attend to their own medical issues, to attend to medical issues for a family member, for a qualifying family member who is suffering from severe medical issues. And it also provides opportunities, for instance, for employees who are in the process of either bringing children into the world, as in terms of a newborn, or undertaking opportunities to care for other children, such as foster children or children that are being adopted. And one final prong to this is, I'm sorry, I'm just not happy at all. Can I do it again?
Sure.
Sorry, Ashley, but I'm just going to start again and pull it together. She's like screaming when she's muted. All right. Sorry, I'm like learning this stuff. It's covered later. Thank you, Steve, for that introduction. Oh, sorry. Starting again, forgot to change the slides. Thank you, Steve, for that introduction. As he mentioned, my name is Rachel Young. I'm a partner with the law firm of Tully Rinckey, and today I'll be speaking on the topic of the Family and Medical Leave Act versus the Rehabilitation Act. And we'll be exploring the opportunities for coverage pursuant to these 2 laws and the interfacing in terms of what opportunities they might provide to someone who might need different forms of coverage for the same or similar situations. Thank you so much for joining us today for this discussion. So to begin, I'd like to provide you with a brief overview, or the highlights, if you will, of the coverage that is provided pursuant to the Family and Medical Leave Act, or what I'll refer to as the FMLA, as well as the Rehabilitation Act as well. The FMLA provides federal employees with up to 12 weeks of leave during a 12-month period for a variety of reasons that we'll go into detail in a few minutes. So for qualifying employees who are suffering from, for instance, an example is a serious health issue that affects the employee, or for qualifying family members, there is an opportunity to receive, approximately 3 months' worth of leave that is protected pursuant to this particular act. One of the benefits of the FMLA is that, employers such as the federal government have to provide the employees leave if they meet the qualifying conditions of the act. Furthermore, employers are prohibited from either interfering with the employee's right to receive such benefits, as well as from retaliating against employees who do make requests for leave under the FMLA Act. So one of the key benefits of the FMLA is that when a medical situation or some sort of personal situation arises for employees or for their families, it affords an opportunity for employees to receive up to 3 months of leave, whether it be consecutive or it can be intermittent for different types of leave, and it guarantees you the right to return to work at the end of that period. And that's one of the key benefits of the FMLA. Moving along, I do want to give you a few sort of highlights on what the Rehabilitation Act provides you in terms of opportunities. The Rehabilitation Act is similar to the Americans with Disabilities Act, but this is the provision or this aspect of the law that applies to federal employees. The Rehabilitation Act has several key features that are also very beneficial. Number one, it prevents and protects federal employees against discrimination in the workplace on the basis of disability, and we'll talk about what disability means in a few minutes. But in addition to that, it affords employees that are suffering from physical or mental impairments the opportunity to receive reasonable accommodations for their medical condition. And a reasonable accommodation can be something that helps them do their job through the provision of equipment. It could be some sort of modification to a work schedule or to some other policy or procedure that the agency has in place. So there's a lot of benefits for coverage pursuant to the reasonable accommodation prong of the Rehabilitation Act, as it does give you the opportunity to make modifications to the workplace or to policies that can allow someone who is disabled to do their job and to perform service in connection with the agency's mission that they work for. So there's a lot of benefits there. We'll talk a little bit more about that in a few minutes. Also, this is a statute that does include a retaliation provision. The federal agencies are prohibited from retaliating against any employee who either A, requests reasonable accommodations or qualifies as disabled under the law. So there's a lot of protections there between these two acts, and we're going to move into talking about the interfacing and the pros and cons and the benefits of seeking coverage under each particular provision. What I'd like to do is to move forward and to spend a few minutes focusing specifically on the FMLA and what that means. The FMLA applies to employees both in the federal sector as in the private sector, state employees as well. So as you are learning the law today, through this presentation, I do want to just make it clear to you that my comments are being directed primarily towards federal employees. So if you have, other friends or family members that are, also interested in coverage, pursuant to the law, there may be some differences between what applies to those people versus what applies to federal employees. So with that qualified, one of the key benefits about the Family and Medical Leave Act is that it provides, like I said, the 12 weeks of leave, but you have to meet the qualification. So with this statute, as well as with the Rehabilitation Act, I think the first step in the analysis is to figure out, am I someone who is covered under the Act, and how do I become covered? And that's what we'll be talking about for a few minutes. So in evaluating if you are covered, one of the first steps in the analysis is the question of how long you have worked for the federal government, for the government as a whole, not for a particular agency. You have to have worked for the government for at least 12 months in order to receive coverage. And during the course of that period of time, you have to have racked up, if you will, 1,250 hours during the course of the past 12 months. Once you have met those underlying standards, then you have met sort of the preliminary qualifications for coverage under the FMLA. As I mentioned a few minutes ago, the FMLA provides protection in approximately 4 different types of situations. And I wanted to go into detail as to what those situations might entail. First of all, it applies to an employee who is suffering from a personal, serious medical condition. For instance, I'll use cancer as an example of what might be qualifying under the FMLA as a serious medical condition. For people who are suffering from medical situations that are serious, in evaluating what constitutes a serious medical condition under the law, we look to the actual definition that Congress has approved, if you will, under the FMLA. And I've included that on the next page of the slides, but for our purposes now, what we're looking for is someone who is experiencing an illness, an injury, an impairment, or a physical or mental condition that involves either inpatient care or outpatient care, meaning that you're undergoing continuing treatment by a healthcare provider. This is very, very broad coverage, and it's very beneficial coverage because it affords you the opportunities not just for, situations where you're in inpatient care, such as in a hospital or hospice, but also in situations where you are undergoing, ongoing treatment from a physician. So to utilize the example of cancer, someone that's undergoing chemotherapy, which is a routine, consistent, recurring treatment plan, might qualify under the broader provisions, even though they're not subjected to any sort of inpatient care. So that's certainly the definition of a serious medical condition, and it applies both to A, your personal situation if you need to go out for yourself, as well as the second prong is for qualifying family members who may also be subjecting to serious medical situations. So if you have a parent or a child or something along those lines that is experiencing a serious medical situation on their own, you can, as a federal employee, also find protection under the FMLA so that you can take time off of work to attend to their needs. Next, under these 4 different types of qualifying conditions, we have your personal health care conditions, we have that of qualifying medical situations for your friends and family members. And then another prong is for essentially the placement of children in a home. There are many different ways that children can be placed within a family, and the FMLA does recognize that. So it extends protections for coverage to people who are introducing a newborn into their family, as well as people that are having a son or daughter placed with them through the provisions of either a foster care arrangement as well as adoption. So all of those circumstances are covered from the perspective of the Family and Medical Leave Act for providing up to 12 weeks of leave during the course of the year. Last and certainly not least, there is a provision that affords 12 weeks of leave that is protected under the law for individuals that are undergoing military or active duty situations. So one of the prongs that is also covered here is for qualifying situations that arise from a child or from a spouse or from a parent essentially entering active duty within the armed services of the United States government. So there's also protection in that form as well. So as you can see, in evaluating who if you are someone who is subjected to coverage under the Act, there are very broad protections for people, and most situations that arise, within the context of the workplace can fall into one of these different four categories, provided that these terms and conditions are met. Moving forward then, we've talked about who is subjected to coverage under the FMLA Act, and I want to talk a little bit more about who is covered under the Rehabilitation Act as well. The Rehabilitation Act has a more narrow form of coverage, if you will. In order to qualify under the Rehabilitation Act for coverage, we have to be someone who is deemed to be a qualified individual with a disability. And that is a very precise term that is defined under the law. A disability is defined under the Rehabilitation Act as having a physical or mental impairment that substantially limits an individual in one or more major life activities. That is the pure definition of the term disability. However, there are more liberal interpretations as well of who can qualify under the Disability Act. The other two prongs for coverage include people that may have a record of having such an impairment. For instance, someone who may have suffered from some sort of physical impairment dating back, 2 years, 3 years, or 5 years, but somehow there's a record of you having this condition that the agency is aware of. And the most broad provision applies to someone who is regarded as, or what we say in my typical lingo, someone who is perceived as having a disability. For this latter category, you may be someone who is not suffering from a very serious physical or mental impairment, but your employer, for various reasons, may perceive you as being someone who qualifies. And what's great about the Rehabilitation Act is it covers those types of situations as well. If we look at the more narrow provision of being qualified individual with a disability, which is the first prong of coverage under the Rehabilitation Act, we have to evaluate if you meet the standard and if you are able to perform the essential functions of your position with or without reasonable accommodation. From the perspective of an attorney who litigates a lot of cases under the Rehabilitation Act, fortunately or unfortunately, there are a number of different areas for discussion as you are evaluating if you are someone who is covered and if you have a claim that should be brought pursuant to this law. And no case is alike, frankly. In each situation that I approach where we are evaluating whether someone is covered under the law, if we have an instance where there is coverage, perhaps you may meet one or more of these different provisions. So from a strategic perspective, looking at the potential type of claim that you may be bringing or the type of protection that you may need from your agency, we have to evaluate and make sort of a strategic determination as to which prong to pursue, what's most beneficial for you in your particular case. And to give you an example of that, if you are someone who is seeking a reasonable accommodation for a disability that you have, if you need, for instance, perhaps you're suffering from dyslexia and you might need some sort of software, some sort of corrective software that helps you type and produce work products in the workplace. If we have those types of situations, generally we do need to proceed under the qualified individuals with a disability prong. So we have to meet the legal definition of showing all of these various things in order to then show you're entitled to a reasonable accommodation and to show that the accommodation that we are seeking will enable you to perform the essential functions of the job. So in terms of evaluating coverage, oftentimes, it's not simply about this legal definition and figure out if you meet it, but it's also about consulting with your counsel to figure out what is the best approach that should be taken with respect to proceeding on the claims that you're raising. So now that we've talked about the topic of, am I covered, then we want to move forward in understanding the interfacing between the two laws. it is possible to have coverage under both laws. So in making a strategic evaluation as to, for instance, how to request leave and, should I bring a request for leave under the FMLA? Should I bring a request for leave or something else under the Rehabilitation Act? We want to make a sort of strategic analysis there to figure out what's best for you under your specific situation. So moving forward to the next slide, we've prepared sort of a short summary of the benefits under each act so that you can compare and contrast what might be best for you personally in your situation. So starting with the first line, as I sort of emphasized here today, FMLA affords people up to 12 weeks of leave. That is the duration for coverage, 12 weeks of leave under the FMLA Act. Now, everyone's situation may not lend itself simply to 12 weeks of leave. And that's where the Rehabilitation Act comes in. It may afford a broader opportunity for coverage that may be longer in duration. So from the perspective of the FMLA, what employees are afforded are up to 12 weeks of leave in 12 months that is covered. That leave, like I mentioned before, does not need to be taken consecutively. It may be taken intermittently if the situation arises. So I've represented in the course of making requests for FMLA leave, everyone's situation is not different. If there's someone going out for surgery, for instance, you may need to be out for a consecutive period of time. But if your situation is different, it might give rise to a circumstance where over the course of maybe 12 weeks or 3 months or longer, you have to undergo some sort of treatment plan that requires intermittent leave. And the agency does have to afford you the opportunity for intermittent leave as well. As we talked about previously with respect to the FMLA Act, leave is not limited to just the employee themselves. There's opportunities for pregnancy leave, if you're bringing a newborn or someone else into your family. There's opportunities to take FMLA leave to care for the family as someone is actively deploying in the military. There are opportunities for care for parents, for siblings, for children, et cetera, who are suffering from medical conditions. So the scope of the FMLA Act in terms of who it applies to is far broader. From the perspective of the Rehabilitation Act, you're looking specifically at you as the employee and what your specific needs are under the Act. So that's a key difference in terms of coverage based on these two laws. Under the FMLA Family and Medical Leave Act law, if you meet the standards the agency has, absolutely has, to provide you with up to 12 weeks of leave, there is no wiggle room, there is no room for debate. If you meet the standard, the agency has to provide you with that leave. By contrast with the Rehabilitation Act, leave is not something that is guaranteed. It truly depends on the situation and the circumstance, and the ability to seek leave and to proceed with leave is the result of usually an interactive discussion between the employee and the agency as to best accommodate that condition. One of the things to remember under the Rehabilitation Act is once a request for leave or some sort of other accommodation is made, the employer does have a responsibility to engage in what we call the interactive process, which is a back and forth process between the employee. If you retain counsel, as many people do for these situations, then the counsel would take the primary role in the interfacing between the agency's reasonable accommodation coordinator and the agency itself to figure out what the best thing is. Now, under the Rehabilitation Act, the agency does not have to give you exactly what you were looking for, which is a critical difference from the FMLA. It is the result of discussions that should lead to an overall solution that accommodates the employee's particular condition, whether it be the need for leave or for something else. So with the FMLA, the law is much more rigid. With the Rehabilitation Act, there are opportunities for discussion and, frankly, opportunities for problems if we run into problems with the agency complying with the law and what the terms of the law provide. From the perspective of litigation, we've also included an aspect here under the FMLA that notes that there is no requirement for the administrative exhaustion of an employee's rights under the law. If the agency violates your request for FMLA leave or interferes or retaliates, you do not have to exhaust your rights by going through the administrative process. First, you can take direct action to sue the agency or to pursue with a DOL claim, which is the Department of Labor, pursuing relief for those violations. By contrast, if you have made a claim pursuant to the Rehabilitation Act, if you're being subjected to disability discrimination or your request for reasonable accommodation has been denied without justification, there is still a process that you have to go through in order to vindicate those rights, which is known as the EEO, or Equal Employment Opportunity process for federal employees. So if you find yourself in that situation, I would advise that you speak with an attorney as to what that process entails and the pros and cons of enacting that process, as well as timeline to enact that process. So we've included here, as I've mentioned, a number of different pros and cons here, with potential benefits for each act. I won't go into detail about all of them here, but as you can see, there's a strategic analysis that you have to apply when considering, if I'm in a situation where I have a medical condition, what is in my best interest to do? And depending on the specific circumstances that you're facing, one might be beneficial than the other, one might be pursued before the other type of leave is pursued. So it really does depend on the specific situation, what to request and how to do so. Having covered some of those duties, I'd like to move forward in talking about a couple of the other similarities that I have not already addressed, and some of this I frankly have addressed already. One of the key similarities between leave that is being sought pursuant to the FMLA Act or leave that's being pursued pursuant to the Rehabilitation Act is the need generally for medical documentation. Most agencies will require that a request for FMLA leave or request for leave under the Rehabilitation Act is supported through medical documentation, from your treating healthcare provider. Another similarity is I spoke about, either consecutive leave or intermittent leave. Both forms of leave are supported under both acts. So if you have a situation, for instance, where you're undergoing treatment for cancer, that might be supported for intermittent leave under the FMLA Act, as well as leave requests that are made pursuant to the other acts as well. The key difference here between the two acts is the clock is running on FMLA leave, meaning that it's adding up to either the number of hours that constitute 12 weeks of leave, which I believe is 480 hours, or the 12-week requirement itself. So with that being noted, I did mention in our discussion of the prior slide that employees that are making requests or claims that the agency failed to comply with the provisions of the Rehabilitation Act have to file EEO complaints. And the general rule as it relates to EEO complaints, we can talk for hours about the EEO process, but the general rule that I want you to take home with you today specifically is that if the agency is discriminating against you on the basis of your disability, remember that you have 45 days from that act of discrimination, notice of it, to contact an EEO counselor to initiate that process. By contrast, if you have been discriminated against under the FMLA or retaliated against under the FMLA, a lawsuit has to be filed somewhere between 2 to 3 years, depending on the nature of the violation itself. As I've sort of alluded to before, there are situations where people need to request leave under both laws, consecutively or at the same time. There is nothing prohibiting you from taking leave under the FMLA at the same time that you're using leave under the Rehabilitation Act. What I would simply suggest to you here is if you find yourself in a situation where you think you need both, my advice to you is simply consult with an attorney talk about what the specific parameters are. There are lots of pros and cons, and what we want to try to do is to analyze and apply the law in a way that best benefits you. So depending on specific circumstances, we may want to take the leave at the same time. We may want to use one form of leave after another. We may want to institute similar leave immediately because of the expedient need for leave for whatever the circumstances require. So there's a careful analysis here that you would want to employ in figuring out what your need for leave should be and what the request should be made to the agency under those terms. Requests for leave under the Family and Medical Leave Act, from the one downside from an employee's perspective to the FMLA leave is that it does not provide you with an opportunity for paid leave. The leave is unpaid under the Family and Medical Leave Act. However, as a federal employee, many of you have racked up, very huge and substantial leave balances. So if you have a great deal of annual leave and sick leave, or even if you have only a little bit left, what you can do is make a specific request of your federal agency to apply the leave from your balances toward your covered leave so that you can receive pay pursuant to the 12 weeks of similar leave that you are taking under the Similar Act. So with that being said, I believe I've covered sort of the general parameters of the Family Medical Leave Act as well as the Rehabilitation Act as it relates to the need for accommodations in the form of leave. I've alluded to a variety of ways that attorneys can assist you through the process, and that ranges, frankly. When it comes to looking at the analysis of instituting an EEO claim, if you're someone who feels you've been discriminated against under the law based on a particular medical condition that you actually have or that your employer may perceive you as having, you need to initiate the EEO process in order to protect your rights. And as I mentioned a few minutes ago, that needs to be done within 45 days generally. The law does afford a bit more of an opportunity for reasonable accommodation requests that are either not processed expeditiously by your agency. I've seen that happen many times. You make a request for leave and the agency for some reason does not comply with the provisions of the law in affording that person leave immediately under the Act. So there are a lot of different situations that can arise in which you are concerned about the denial of your rights and the need to initiate the EEO process. In the course of my practice, unfortunately, I have had so many opportunities to consult with employees who have missed their deadlines. The deadlines for federal employees are very short for the most part. And under the EEOC's regulations that apply in these circumstances, if a deadline is missed, for the most part, it's very difficult to unring that bell or impossible under many circumstances. So one of the benefits that an experienced counsel can provide to you is the ability to navigate the process as it relates to making sure that those deadlines are met. Most of us know those deadlines are asleep and have a lot of experience litigating around those deadlines. And we can help you navigate the process of ensuring that your case does not end up dismissed or tossed out simply because of a failure to meet a deadline. Even after the 45-day deadline is met in the EEO process, there are many other deadlines that apply, ranging from 15 days in some instances to longer periods of time. But what we can do is help you navigate that process to ensure that all of those hurdles are cleared, and we can move forward to talking about the issues that actually matter in your case. Another way that certainly employees can benefit from having counsel in these situations is, leveling the playing field, frankly. Agencies employ attorneys mostly on their staff. They have, dozens of legal attorneys that are there to assist them in the process. Sometimes you may know the attorneys are involved, many times you do not. They're behind the scenes, guiding human resources, guiding the supervisors, and giving them counsel that is in the best interest of the agency. So having someone that's there to stand up for your rights and to help you navigate the process is excellent. Another area that I can sort of reference here is while agencies should comply with the law, doesn't mean they always do. And I've been in business, helping people secure their rights for many years. So what I can suggest to you is, for instance, if you make a request for reasonable accommodation, I can think of a dozen cases just off the top of my head right now in which people made very reasonable requests for accommodations and ran into problems with their agency who either argued that it was removing an essential function or made some sort of argument to try to avoid providing people with the accommodations that they need. So one of the things that is beneficial from having counsel is that counsel knows the law, and counsel can help you ensure that you are not falling victim to a ploy from your agency, ensuring the agency complies with the law and provides you the rights that are afforded to you under these different provisions. If you need further information, I'd be happy to speak with you as well as any other member of this firm to give you guidance and to counsel you in situations, either through, directly with your agency or simply speaking with you one-on-one to discuss something that's unfolded and to give you advice and counsel in terms of how to proceed. We've included on the screen in front of you some information that hopefully will be beneficial to you. And if you need to consult with our firm, we'd be more than happy to do so. So at this point, I'd like to thank you for your time today. I'd like to thank you for the opportunity to present this information to you. If you have questions or need more information, reach out to us. We're only a phone call away. Thanks so much.
Thank you for participating in this webinar. If you'd like to learn more about how to best defend your federal career, call 1-888-529-4543 or email info@fedattorney.com to schedule your free consultation with a member of our team. As a reminder, our experienced team of national security clearance attorneys regularly assists federal employees and contractors, as well as military personnel in all stages of the security clearance process. They've helped hundreds retain their clearances. Our military law team is nationally recognized for its ability to win cases against tough odds. Our military lawyers have proven track records of changing the military law landscape through knowledge and tenacity in all matters faced by service members, including but not limited to courts-martial, discharge upgrades, and desertion. Don't leave the future of your federal career to chance. Call 1-888-529-4543 or email info@fedattorney.com to schedule your free consultation with a member of our team.